right, chat. So AI and law don't really mix. And there's been an uptick in both what are called pro se litigants, where someone is trying to represent themselves in a court case, and attorneys using AI basically for the worse. So first, I have the story from Above the Law. Appellant sends AI avatar to oral argument. The judges are not pleased. You've heard of lawyers using AI to do their research or even draft briefs, but sending an AI avatar to deliver the oral argument is a new one. So we'll see this in a moment, but this is the AI avatar that this pro se litigant used. You might notice that he is a white guy in his mid to late 40s, early 50s. I wonder why that is. In DeWolf v. Mass Mutual Metro, the appellate division first department expected some sort of audio-visual presentation as part of the pro se litigant's argument. It's not exactly standard procedure, but the justices were willing to accommodate an unrepresented party. The panel even took the matter out of turn to accommodate the relevant IT issues. That's when they were treated to a few seconds of this generic tech bro robot representing the appellant. Let's take a look at that.
Versus Mass Mutual is being called out of turn, and the appellant has submitted a video for his argument. Okay.
Chat, type 1 if you think this is about to be an absolute cluster. Type 2 if you think this AI is about to give a very nice, very well-reasoned legal argument. 111111111. Good job, chat. Good job, chat. Good instincts. Good instincts.
Okay, we will hear that video now. Versus Nelson is submitted. First case argued on the calendar is HSBC Bank versus Mint. A video for his argument. Okay, we will hear that video now.
May it please the court. I come here today a humble pro se before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
Took 3 seconds. Took maybe 2.5 to 3 seconds. The immediate uncanny valley. Let's take a look at this. May it please the court. That's what you say when you start an argument in front of an appellate division court. I come to you as a humble pro se litigant. That means you're someone who's unrepresented. But this is person now being represented by a guy who is apparently blinking. The AI blinks now. And look at what he's wearing. A khaki kind of sweater situation with an unbuttoned top button. You could at least, create an AI attorney in a suit. I'm sorry, but I find this hilarious and sad. It is hilarious and sad.
I'm sorry? Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal...
Chat, as a note, whenever the judge starts talking to you like this means you are fucked.
...conversations with our staff for over 30 minutes, okay? I don't appreciate being misled.
So she goes on to basically say that if... Oh, she's pissed. She was pissed. You've appeared before this court and been able to testify verbally in the past. You've gone to my clerk's office and held verbal conversations with her staff for over 30 minutes. Okay, I don't appreciate being misled, so either you are suffering from an ailment that prevents you from being able to articulate, or you're not going to use the courtroom as a launch for your business, sir. So if you're able to shut that off, if you want to have oral argument time, you may stand up and give it to me. You have 5 minutes. Your time's now started. So, following that moment, the pro se litigant reads off what would have been the AI script. And he's bumbling. He's not having a good time about it. But, this has just been kind of one moment for a non-attorney using AI that's kind of gone absolutely, totally bottoms up garbage. Now, you might be thinking, a trained attorney wouldn't be doing this. Oh God, it's his own company. That's not absolutely clear, but there are a bunch of different LLMs that are offering legal services. And there are some companies and some law firms that are creating their own AI models that they are then using. I think a good example of that would be Morgan & Morgan. Chat, if you don't know, Morgan & Morgan is basically the largest personal injury law firm in the country. It is one of the largest law firms. It's one of like the only large plaintiff side law firms for normal people. You probably have seen a lot of their billboards before. Let me grab one of them for you, because they are kind of obnoxious and they appear on basically every single highway known to mankind. One of these. Use a hurt, and then, you know, Mr. Morgan, fat guy, right there. Fun fact, this is also the firm where Robert F. Kennedy Jr., the current secretary head for the Department of Human Services, used to work at before he joined the Trump administration. So, you know, very high quality law firm right there. Another hard-learned lesson case on Monday, February 24th, 2025, about a month and a half ago. A federal district court sanctioned 3 lawyers from the national law firm Morgan & Morgan for citing AI-generated fake cases and motions in limine. Those are motions to suppress evidence. Of the 9 cases cited in the motion, 8 were non-existent. It wasn't just, you know, one fake case that they cited. They only had one real case. Although 2 of the lawyers were not involved in drafting the motions, all 3 of them e-signed the motions before they filed. Yes, Marin. So, basically, the lawyer who drafted the motions admitted, after the defense counsel raised issues that they weren't real, that they used mx2.law to add case law to the motions. mx2.law is, quote-unquote, an in-house database launched by Morgan & Morgan. They have their own unique AI law database that is hallucinating more cases than real cases. The lawyer admitted to court that it was their first time using AI in this way. Unfortunately, they failed to verify the accuracy of the AI platform. So it's their first time using AI. They don't bother to freaking check it. To Morgan & Morgan's credit, they withdrew the motions, were forthcoming to the court, reimbursed the defendant for the attorney's fees, and implemented, quote-unquote, policies, safeguards, and trainings to prevent another such occurrence in the future. The court sanctioned all 3 lawyers. The attorneys who drafted the motions that failed to verify the output was sanctioned $3,000. And the other 2 who e-filed the motions were sanctioned $1,000 each. So that's $5,000 in total. This is not the first hard lesson learned by an attorney who cited fake cases in the court documents. That's happened now multiple times. So using AI is just proving these people don't do their due diligence. No! And the worst part is that, why were these lawyers not, disbarred? I would absolutely make a bar complaint about the attorney who did this if I was the client. Because again, Morgan & Morgan usually is representing normal people. They're mostly a personal injury law firm. I would absolutely make a bar complaint against my attorney if this happened to me. The worst part is that it is incredibly easy to determine if cases are real or fake. You can either, go through and check them, spend 5 minutes checking them, and there's also algorithms. LexisNexis, Westlaw, both have pseudo AI where you can submit like your brief or your motion before you submit it to the court, and it'll just check and make sure that your cases are both real and that they stand for what you say they're standing for. Can you sue your lawyer for doing this? So this would be malpractice. And if the lawyer lost the case doing this, maybe this could come to the level of being malpractice if it caused an issue in the case that affected the results of the case. This is a motion in limine, so this is a motion to exclude evidence. It's unlikely that a motion in limine is kind of the turning point of the case, but it's certainly possible. Isn't there a database you can go look up a case exists? Yes! Westlaw, Lexis. Take 30 seconds. You can even just submit the entire brief to them, and they'll make sure all of the cases exist. It takes 45 seconds. It used to take hours. You used to painstakingly have to go and get what were called like case books volumes of reports. You'd have to look through like hundreds of pages of books to determine, if the case is real, if it's being cited. It would take hours to make sure you're citing, cases properly. In the 1970s, 80s, fake cases didn't exist, obviously. So, maybe, one fake AI lawyer in court, a couple of fake cases. It can't get worse than that. It can absolutely get worse than that. Same freaking month that this happened. Almost the exact same day, actually. This keeps happening. February 24th, 2025. This one happened the next day. A federal magistrate judge has recommended $15,000 in sanctions be imposed on an attorney who cited non-existent court cases concocted by an AI chatbot. That first judge, $3,000 to the attorney who effed up. This judge, $15,000. In a report filed last week, Mark J. Dinsmore, U.S. Magistrate Judge for the Southern District of Indiana, recommended that attorney Rafael Ramirez of Rio Hondo, Texas, be sanctioned $15,000 for filing fake cases in 3 different briefs, where he failed to appropriately verify the validity and accuracy of the case law cited to the court-imposing counsel. So if they do that without your consent, prior knowledge, and it takes your case down to the bottom of the river, can you sue the lawyers who do that? The answer is always, it depends, Roderick. And I would say, I would definitely talk to another lawyer about suing your first lawyer about this. I think that's absolutely something appropriate to do. Back on October 29th, 2024, Ramirez cited 3 non-existent cases in a brief. Dinsmore, the judge, in December ordered Ramirez to appear in court and show cause why he should not be sanctioned. So in order to show cause basically means that the judge has decided that you screwed up and you have an opportunity to beg the court for forgiveness why you should not be sanctioned for a lot of money. Transposing numbers in a citation, getting the date wrong, or misspelling a party name is an error, the judge wrote. Citing to a case that simply does not exist is something else altogether. Mr. Ramirez offers no hint of an explanation for how a case citation made up out of whole cloth ended up in his brief. The most obvious explanation is that Mr. Ramirez used an AI generative tool to aid in drafting his briefs and failed to check the citations there before filing it. Chat, I'm going to admit something to you. I have used AI before for for legal research. It is something that can be really helpful if you're trying to determine, for example, what are the factors that go into determining the standard for a case. But you then assume it's hallucinating 80% of what it's giving you. You go and you check. You do the hard work. You don't just, throw it into your brief where you're probably billing your client or the court, $300, $400, $500, $600 an hour. No one should be getting paid $600, $700, $800 an hour to use ChatGPT. Mr. Ramirez admitted that he relied on programs, utilizing generative AI to draft his briefs. Mr. Ramirez explained they used AI before to assist with legal matters such as drafting agreements and did not know that AI was capable of generating fictitious cases and citations. While Ramirez insists that he did not act in bad faith, he did acknowledge not fully complying with Federal Rule of Civil Procedure 11, which requires attorneys presenting materials to the court to certify its accuracy to the best of their knowledge. Chad, you might be like, what's Rule 11? Here's Rule 11. So Rule 11 is basically the Federal Rule of Civil Procedure, the rules you have to follow in civil court on the federal level. And if a court ever brings up Rule 11, you're screwed. You are screwed. This is basically the rule that says, if you mess up any of this, you're getting sanctioned. If you're lying to the court, you're getting sanctioned. Everything that you sign off on, you're saying you did this. If you didn't, you're getting sanctioned. You have an opportunity to withdraw stuff before you get sanctioned. If you don't do that, sanctions. Dinsmore noted that while the penalties recommended is at the higher end of sanctions that have previously been imposed for similar conduct, Mr. Ramirez's professed ignorance of the propensity of AI tools to hallucinate citations evidence that those lesser sanctions have been insufficient to deter the conduct. Basically, the court's saying, we've given $3,000, $5,000, $10,000 sanctions in the past, and people are still doing this. They're not taking it seriously. $15,000. Bailiff whack his pee-pee. So, looking at the actual recommendations for a second. Again, it's not just, one brief. It's 3 different briefs. Other findings in the case reveal citations to other briefs that the unsigned rate will locate. Northern Manager Inks v. Cox, and then Brown v. Local. And you see, it creates fake case names, fake case citations, even, fake years. So it looks real to the start to anyone who is just looking at it without actually digging into it. Because generative AI algorithms are just like, kind of like word guessing games. We're trying to guess the next word that comes. So it's able to put them up into a pattern. Me being convicted of murder I didn't commit. Lawyer pulls out AI for anything. Your Honor, I would like to confess. No, Marin. I think if your attorney is just busting out the chat GPT at the first sign of trouble, that's a problem. I would not use this lawyer again. Hey, I hope you enjoyed that video and learned something. Please don't forget to leave a like, and if you think you know more than me, leave a comment and I'll take a look. Don't forget to subscribe, and if you want to let the algorithm feed another legal video down your gullet, please click on your screen right now. Thank you.